Good morning, Ms. Parker. Can you hear me okay?
Good morning. Yes, I can. Can you hear me okay?
Thank you for being here with us today. We'll get started in just a few minutes, okay?
Thank you.
Thank you. Good morning, everyone. This will be the ORCA motions calendar and the ORCA bench trial calendar. Let me call the calendar and see where we are this morning. Position number one, Tanya Combs.
Honor, Ms. Combs is right outside pretrial judge.
Okay. Position two, Yannick Kinsaka.
Judge, I've not heard from Mr. Kinsaka. I had filed an immunity motion, but I actually informed the state that I'm withdrawing it. So it's withdrawn. So I don't really have any motions, Judge. And typically, I mean, I don't know what to do with this case other than probably it has to go back to division. Since he's not here, unless he shows up, I'll try and see if he is interested in taking a plea.
Okay.
That's where we're at, Judge.
The case will be returned to the division judge. Okay. Have you been in touch with him?
No, Judge, and my objection to the bench warrant on a motions calendar, Judge, is that normally if the person doesn't show up, he waives or she waives their right to motion. It's not.
Okay.
Making a bunch of assumptions about notice that went out and intention.
Well, I mean, that
he's been here before.
He has.
We placed him on the calendar before. I'm not sure what the problem
in
is.
fact, Judge, I've not had personally contact, but he called Ms. Rosenhuber, who was his lawyer before Ms. Shelley. And she spoke to him, and she gave him my phone number. I called and left him a message. And knowing Ms. Rosenhuber, I know she told him about the court date. So I know also I believe he has out-of-state contact. So I don't know if he's living out of state, but I've not personally talked to him.
Well, let me see if I can maybe satisfy you both. What I'll do is I'll put it on a status conference calendar before myself. And if he doesn't show at that point, I'll issue a bench warrant. If he does show, then you can tell me where you would like for it to go.
That'd be fine, Judge. Thank you.
Let's place it on the status conference calendar. The only one I have is August 2nd.
Sounds good, Judge. Thank you.
Okay. Position number three, the last name is Obas.
She's here. This is going to be negotiated. Hopefully the state has the paperwork. Okay, great. That makes sense.
All right. Position number four, Sharon Watts.
It's what?
She's present, Judge, pretrial.
Okay. And for the ORCA bench trial calendar, I know that Mr. Jackson is here. Yes, Mr. Jackson, have you had the opportunity to speak with the solicitor? Okay, what would you like to do today? Say it again. Okay. I do have, and I'm just wanted to ask you this, I'll go through a formal hearing. You understand that you have a right to have an attorney represent you in this matter. We've given you the opportunity to hire an attorney. You haven't done that. I've given you the opportunity to meet with, or have a public defender, see if you qualify today. It's my understanding that you don't wish to do that either. Okay, so, once I complete the pre-trials here, we will have your bench trial, sir.
Right, I may just, I have the letter hearing documents, the waiver that I'm going to provide to Mr. Jackson to sign, as well as, the plea verdict form so that we can go this issue.
Okay.
Just an update on my witnesses, Miss Rhonda Johnson.
Your Honor, I'm sorry, I can't hear what you're saying.
And we are awaiting the arrival of Officer Curtis of South Fulton PD. As you know, this case was bumped up to the morning. And so his estimated time of arrival is gonna be around 10:15.
Okay.
10:15 and 10:30.
Okay, once you handle the other business, can we start the trial prior to him getting here with your other witnesses, or do you have a certain order that you prefer to take him in?
Your Honor, I think we'll be able to start prior to him getting here.
Okay, all right, so you all just let me know, we'll be in recess. Let me know when you're ready to proceed with
Thank you.
any matters. Okay, we'll be in recess until further notice.
Thank you.
Yes, Mr. Dunn.
Your Honor, on position number 2, Mr. Kinsaka, he is present, Judge. I spoke to him. He's gonna maintain his not guilty plea, Judge, and requesting a trial, Judge.
Okay. Yes, good morning, Mr. Kinsaka. Your client has a question, Mr. Dodd.
I think the question is whether he can do Zoom because he lives in North Carolina. I explained that it depends on, the trial obviously got to be in person, but I'm not sure if Judge Morrison is gonna have a status, and I honestly, I don't know. Each judge seems to operate differently, so that's what I
Okay.
told him.
All right, so yes, sir, your case will be returned to the division judge. You'll get notification of your next hearing date.
Do you know what question?
Mr. Haddad can let you know, okay? And you'll get notice, make sure that, I'm sure Mr. Dodd will make sure that he has all your contact information and that it's updated with the clerk. No.
How you doing? You need some help?
I'm good. Yeah.
Have a blessed day.
Have a good day.
Hold on, sir.
We get updated contact.
Oh, sure.
Oh.
Yes, Mr. Day.
Judge, on position number one, Tanya Combs, Ms. Combs, the state had extended a recommendation of reckless. I've communicated that offer. Ms. Combs is not interested in any kind of a plea. She maintains a not guilty plea. So that's where we're at, Judge.
Okay, the case will be returned to the division judge and, where are you, Ms. Combs? Yes, good morning, Ms. Combs. As such, your case is gonna be returned to the division judge. You'll get notification of your next hearing date, ma'am. Let me make sure that we have your updated contact information before you leave today, and, you have everything you need from her?
I do,
Mr.
Judge.
Haddad? Okay, so we can, and once you, give us your updated contact information, Ms. Combs, you're free to go this morning, okay? Thank you, ma'am.
And Judge, we're ready on position 4. That's gonna be a plea this morning.
Okay, Ms. Watts?
Yes, Judge.
Okay, just Ms. Watts will come on up if the prosecution's ready.
And we're also ready on position number 3, Judge.
Okay, I have both those.
Yeah.
You go ahead and swear.
This is the court.
You just want to affirm that the testimony you're giving today in these matters are the truth, the whole truth, and nothing but the truth, so help me.
Yes,
State your name on the record.
Sharon Watts.
Good morning, Ms. Watts.
Good morning, Judge.
Ms. Birch?
Thank you, Your Honor. This case is the state of Georgia versus Sharon Watts, accusation number 20 CR 002387C. We have reached a negotiated resolution. The state has agreed to, the defense has agreed to plead guilty to the reckless driving, with the conditions being 12 months probation, served 24 hours, credit for time served 24 hours, 40 hours community service, risk reduction course, victim impact panel, alcohol, drug evaluation, and any required treatment, and a $300 fine. And in exchange for that, the state has agreed to null cross all other counts in this case, which would be count 1, basic rules, 2, fast for conditions, count 2, possession of open alcohol container, count 3, following too closely, and count 5, DUI less safe. I do understand that the defense is going to ask for this to go non-reporting upon completion of conditions, and the state would have no objection to that, Your Honor. Will the defense stipulate to factual basis, venue, and identification for purposes of the plea?
We do so stipulate, Judge, and we ask you to accept this plea as negotiated.
Nothing further, Ms. Watts. It's my understanding that in case 20 CR 002387C, you wish to plead guilty to reckless driving. Is that correct?
Yes, that's correct.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, more than.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your plea as negotiated, Ms. Watts. As soon as you complete the terms of the negotiated, the terms of the probation, it'll go to a non-reporting status.
Okay.
Is that what you requested?
Yes, Judge, we just have an additional ask about the probation fees, but I'll let the court finish.
Okay, we're gonna tell you where to go to probation today. We ask that, I ask that you report within the next 2 weeks or so, okay?
Okay.
Yes, Miss.
Judge, and I understand this is not a bond hearing and we've already resolved this case, but Ms. Watts is currently working. She just recently got hired at the new Hilton downtown. She has 2 children, 12 and 13 girls, and she has a rent almost $2,000 each month. We're asking the court to waive the probation fees, or as many as the court can, to help Ms. Watts get started in this process. This case is about 6 years old and she's had no other DUI arrest or charges in any other counties and not this county. So Judge, I am asking for those probation fees to be waived.
I can't waive all the fees, but I will waive 2 months to help you get on your feet. So hopefully that'll help out some.
Okay.
And as I said, the sooner you get it done, the sooner you won't be on reporting probation, which means that you don't have to pay the fees once you complete the
class is
terms.
done,
Okay,
yeah.
so the sooner you get that done, the better for you also, okay?
All right. Thank
All
you.
right, good luck to you, Ms. Watts.
Thanks.
Thank you, Judge.
Are we ready on OBAS?
I am, but we are.
The state's ready, Your Honor.
Okay.
Yeah.
Right. You find a affirm that the testimony you given today in these matters are the truth, the whole truth, and nothing but the truth, so that
Yes,
state your name for the record.
liquidated OBAS.
Thanks, Your Honor. This case is the state of Georgia versus Luquatia Obas, accusation number 21 CR 004461Y. We have reached a negotiated resolution in this case. The defense has agreed to plead guilty to DUI less safe, with the conditions being 12 months probation, served 24 hours, credit for time served 24 hours, 40 hours community service, risk reduction course, victim impact panel, alcohol drug evaluation, and any required treatment, and a $300 fine. And in exchange for that, the state has agreed to null process failure to maintain lane. Does the defense stipulate to factual basis, venue, and identification for purposes of a plea?
We do.
Anything further, Mr. Dodd?
Your Honor, I would just request an affidavit of first conviction, assuming the plea goes through.
So Boss, it's my understanding that in case 21 CR 004461Y, you wish to plead guilty to driving under the influence of alcohol less safe. Is that correct?
Yes,
Are you under the influence of any drugs or alcohol this morning?
no,
You've been represented by counsel. Are you satisfied with his representation?
yes,
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
yes,
Has anyone forced or coerced you to plead guilty?
no,
I'll accept the plea as negotiated. When you get through the terms, Mr. Voss, it'll go to a non-reporting status. So the sooner you get it done, the sooner you won't be on active reporting to probation. I'll ask that you go report to probation within the next 2 weeks or so. I will sign that affidavit, first conviction. Anything further that I missed, Mr. Dodd?
No, Judge.
Okay, and you, ma'am.
Thank you. Just, you can stay here until you get a call from. It's fine.
The documents to fill out for.
The affidavit.
Which is already there.
I think so. I'll let check it out. Yeah, she is. So.
I know Will Smith. I watched a lot of Fresh Prince, but that was that was waiting for me. Fresh Prince was like a high school show when I was in.
Yeah.
Send it right now. Sent.
Ms. Helen and Mr. Dodd, do you all have any further business before the court this morning?
No, Judge.
Okay, if you don't, I don't mean to rush you, but can we get defense table, please?
I've never been happy to give that up. Sorry about that, Judge.
No, you're fine.
And my client is filling out the affidavit, Judge, and surrendering her license.
Okay, thank you.
And I think, Judge, I don't remember if the court instructed her as to when she needs to report to probation. Maybe
Within the next 2 weeks or
Okay,
so.
thank you, Judge.
Okay.
That's right.
Yeah.
Judge, have a good weekend.
Yes,
Thank you,
you
Judge.
also. Y'all be safe, okay?
You too. See you guys.
Bye, guys.
So yes, you guys can.
Okay, the court calls the case of the state Georgia versus Jesse Jackson, case 21 CR 002179G. You'll come forward, Mr. Jackson, and take a seat at the defense table. Good morning again, Mr. Jackson. Let's see. If you'll stand and raise your right hand for me, please. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Mr. Jackson, you have a right to remain silent. Anything, you can sit down, sir. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. You've been to my courtroom a number of times before. You've been advised of your right to have an attorney on numerous occasions. I also inquired of you this morning if you would like the assistance of a public defender, to which you said no. Is that correct?
Yes.
Okay. Mr. Jackson, you have been charged in accusation 21 CR 002179G with battery family violence. The accusation reads as follows: State of Georgia versus Jesse Jackson. I, Keith E. Gamage, Solicitor General for the County of Fulton, State of Georgia, in the name and on behalf of the citizens of Georgia, do hereby charge and accuse Jesse Jackson with the offense of battery family violence, first offense, misdemeanor, a misdemeanor for that said accused in the County of Fulton, State of Georgia, on or about May 3rd, 2021, did intentionally cause visible harm to Rhonda Jackson, who is the parent of the same child of said accused, by striking Rhonda Jackson in the face and shoulders in violation of OCGA section 16-5-23.1 F1, contrary to the laws of this state, the good order, peace, and dignity thereof. Signed, Keith E. Gamage, Solicitor General. You have also been charged in accusation 21 CR 002179G with cruelty to children, third degree. The accusation reads as follows: State of Georgia versus Jesse Jackson. Defendant, I, Keith E. Gammon, Solicitor General for the County of Fulton, State of Georgia, in the name and on behalf of the citizens of Georgia, do hereby charge and accuse Jesse Jackson with the offense of cruelty to children, third degree, a misdemeanor for that said accused in the County of Fulton, State of Georgia, on or about May 3rd, 2021, did have acknowledged that a child under the age of 18 was present and allowed such child to see or hear the act of battery or family violence battery by striking the parent of the child in the child's presence in violation of OCGA Section 16-5-70, contrary to the laws of this state, the good order, peace, and dignity thereof. Signed, Keith E. Gammage, Solicitor General. Each of these charges, Mr. Jackson, carries a maximum penalty of 12 months in jail and or $1,000 fine. I have advised you of the nature of the charge against you, the maximum possible jail sentence, and the maximum possible fines. It's my understanding that you wish to proceed this morning with a bench trial and that you wish to proceed without representation of counsel. Is that correct?
Correct.
Okay. And as we go forward, I will let you know what's going to be expected of you with this bench trial, but you have to understand that you have a constitutional right to represent yourself, but there are some dangers that come along with representing yourself. You could be unfamiliar with the rules of evidence, how you get evidence before the court. You could be unfamiliar with trial strategies, with criminal procedure. All of these, the state is very skilled at, but you have to know that going forward, you representing yourself, you may not know all of those rules. You also will have the right to make objections and cross-examine the state's witnesses, but you'll have to do that on your own. You also have to know that you do have a right to remain silent, and anything that you say can be used against you, but you do have the right to testify if you choose to do so. You have the right to present witnesses and defenses and mitigating circumstances if you choose to also do that. It's my understanding that with all that said, that you still wish to proceed pro se. Is that correct?
Yes.
It's my understanding also that you were provided with the Ferretta waiver of counsel prior to the hearing today, and you were also provided with your waiver of counsel and waiver of right to a jury trial. As far as the waiver of counsel on the Ferretta hearing, did you go through each of those questions line by line?
Yes.
And did you put your initial after each of those?
I did.
Okay. And did you sign the bottom of that form?
I did.
And was that with full understanding of what each of the questions asked?
Yes.
Okay. Ms. Waldrop, if the state chooses to do so, I'll allow you to go through the questions if you would like to one by one with Mr. Jackson, if you choose to do so.
Yes, Judge, given that he's pro se.
Okay. So do you have a copy of it?
I do, I have a blank copy.
Okay.
Your Honor, I'm sorry. I'm having trouble hearing the prosecutor and the defense at the table.
Okay. So if we can. Thank you, Ms. Parker. Please, I appreciate you letting me know anytime that you can't hear. Thank you.
Mr. Jackson, do you understand that self-representation is most always unwise?
Wait, what?
Do you understand that self-representation is most always unwise?
Yes.
Do you understand that you may defend yourself ultimately to your own detriment?
Yes.
Okay, and do you understand that you are entitled to no special treatment by the court if you represent yourself?
Yes.
Do you understand that you must follow all of the technical rules of substantive law, criminal procedure, and evidence for the making of motions, objections, the presentation of evidence, and argument, even if you do not know those rules?
Yes.
Do you understand that you will have to abide by the same rules that it took years for lawyers to learn?
Yes.
Do you understand that if you represent yourself, you are assuming full responsibility for your defense?
Yes.
Do you understand that you may miss important defenses to the case because of your lack of knowledge of the law?
Yes.
Do you understand that even if you have some knowledge of the law, you will lose the benefit of an independent perspective of an attorney in analyzing, reviewing, and presenting the case in its most effective way?
Yes.
Do you understand that if you are found guilty, you may not be able to present the case in a manner to obtain the most favorable sentence?
Yes.
Do you understand that your access to the Solicitor General will be reduced, making it more difficult to defend yourself because you will have less of a chance to work out a favorable resolution?
Yes.
Do you understand that the prosecution will be represented by an experienced and skilled attorney?
Yes.
Do you understand that the prosecution's attorney will treat you just as the prosecutor would treat any other attorney? The prosecutor will not go easy on you just because you represent yourself.
Yes.
Do you understand that you will not receive any special treatment or help from the court?
Yes.
Do you understand that if you behave in a disruptive manner in the courtroom, the court can terminate your self-representation?
What that mean again?
Do you understand that if you behave in a disruptive manner in the courtroom, the court can terminate your self-representation?
I'm not understanding what that
It
means.
can't be disruptive. If I find that you're disruptive or that you're not participating in a respectful manner, then, or if I don't, then I can terminate you being able to represent yourself. Okay, I don't expect that you're gonna be disruptive or disrespectful, are you?
Oh,
Mr.
no.
Okay.
Do you understand that if you get convicted, you cannot claim your own incompetency as a basis for appeal?
No.
I'm sorry,
No.
you don't understand?
No.
The court will-
Okay, so you have a constitutional right to represent yourself. Okay, but that question is asking of you that because you make that choice, you are willing to represent yourself and undergo any consequences, both good or bad, that might come from that choice. One of the consequences is that you can't say, I'm going to appeal because I was not adequately represented by my own self.
Okay.
You understand that? Yes?
Yeah. Yes.
Okay, thank you. You can
Do you
proceed.
understand that you will not be given any extra time for preparing the case for trial simply because you are representing yourself?
Yes.
Do you understand that if you had a lawyer, the lawyer would not be subject to those limitations?
Yes.
Do you understand that you have a right to the effective assistance of a lawyer at all stages of this case? And if you cannot afford a lawyer, the court will appoint one to represent you.
Yes.
Do you understand that the lawyer would perform questioning with regard to, Your Honor, I'll skip question number 20. I don't think it applies.
Okay.
Or applies to jury selection. Do you understand that the lawyer may make an opening statement to the court about your side of the case?
Yes.
Do you understand that a lawyer would subpoena witnesses for you, question witnesses against you, and present physical and documentary evidence on your behalf?
Yes.
Do you understand that a lawyer would object to prosecutors' questions and evidence?
Yes.
Do you understand that the lawyer would make various motions on your behalf, such as a motion to keep out prosecution evidence, to dismiss the case, and to give you a new trial?
Yes.
Do you understand that the lawyer will argue your side of the case to the court?
Yes.
Do you understand that the lawyer will prepare and give to the court legal argument, which could be favorable to you?
Yes.
Do you understand that the lawyer will argue for leniency at sentencing if you are convicted?
Yes.
Have you received a copy of the indictment or accusation stating the charges against you?
I have.
Have you read it?
I have.
Do you understand the charges against you?
I have.
Do you understand what the possible penalties are in the case if you are found guilty of all charges?
I wasn't understanding that part again.
Do you understand what the possible penalties are in the case if you are found guilty of all of the charges?
Okay, the possible penalties, Mr. Jackson, would be on each charge, a maximum penalty of a year incarcerated and $1,000 fine. That would be the maximum penalty on either charge.
Okay.
Okay, you understand that?
Hmm.
Yes?
Oh, yes, sir.
Okay, sit up for me. Okay, thank you.
Do you understand that if you are not a citizen of the United States and you are found guilty of the charges, you could be deported from this country, excluded from entering this country, and denied an opportunity to become a naturalized citizen of this country?
Yes,
Do you understand that once the trial begins, you cannot then change your mind and ask for a lawyer to represent you?
yes, ma'am.
Okay. What is your date of birth?
September 30th, 1987.
September what?
30th, 1987,
And how many years of school have you completed?
high school.
Okay. Are you able to read?
I am,
And are you able to write?
I am,
Do you have any difficulty understanding or speaking the English language?
do not,
Okay. Have you previously represented yourself in any civil or criminal case?
I have not.
Okay. Why do you think you could do a better job than a lawyer in representing you in this case?
Cause y'all don't have no evidence.
Okay. Have you ever been under the care of a psychiatrist, psychologist, or other mental health professional?
No,
Has anyone threatened you in any way to get you to waive your right to have a lawyer represent you?
no, ma'am.
Has anyone promised you anything in exchange for giving up your constitutional right to have an attorney represent you in this case?
No, ma'am.
Do you specifically waive your right to have a lawyer represent you in this case?
Yes, ma'am.
Okay, I'm gonna go through how things are gonna proceed, Mr. Jackson, but I don't know anything about your case. Let me just say that, right off the bat, other than, what's on the accusation. I don't know what evidence is gonna come in from, the state. But I'm concerned about the question that you answered, where you say they don't have any evidence. I just want you to know that evidence takes many forms. One type of evidence is testimony that's coming from testimony that'll be coming from any alleged victims in the case, testimony that'll be coming from possible police officers in the case. That's all evidence, okay? So I just want you to understand that evidence is not just you don't have anything on video recording, or you don't have this or you don't have that. Evidence comes in many different forms, okay? So when you said that concerned me, because it's my understanding that they're going to put people on the stand and that they're going to testify, and that will be evidence. You also have the right to present any evidence that you want to present to the court. You have a right to remain silent, but you have a right to also testify if you choose to testify. You should know that if you do choose to testify, you will be cross-examined by the state. I have encouraged you to get a lawyer. I have encouraged you to make application for a public defender. And I just want to make quite sure right now that before we proceed, that you don't want to take me up on my request to have you have a lawyer.
I might need a lawyer now.
Okay? So with full understanding of you would like to see counsel?
Yeah, now I do.
Okay.
There we go.
Okay, would you like to make application for a public defender?
I think I get a paid attorney.
Okay, so I'm gonna give you that opportunity to get a paid attorney. If you come back and you have not gotten a paid attorney, you have not made application. So I just wanted to make sure that you know the possible consequences,
Okay,
and that you do want to get a lawyer. Is that correct?
yes,
Okay, I think I'm gonna have to allow him to seek counsel before we move forward, after being advised of all of his rights and going through that with him. Okay, you'll get notification of your next hearing date, Mr. Jackson. If I were you, I would go out and seek representation pronto. Okay?
Can we request that be something he should proof of when he comes to court the next time, that he has sought representation?
Yes, I think that's fair. And what Madam Solicitor is saying is that don't just come back and say, I couldn't find a lawyer. I'm gonna need some affirmative for you to bring me something affirmative to say, I sought out this counsel and I couldn't get him because of this or that reason. Show me what you have done to obtain a lawyer, okay?
okay,
All right, you have any questions for me?
no,
All right, we'll have to further notice his case. I apologize to To those of you that were here ready to move forward with the trial today, I understand that it's been quite a while. Want to make sure that everybody is properly represented and their rights are they have their full rights afforded to them. All right, anything further this morning?
Has this gentleman
No, Your
ever
Honor.
had an attorney on the case?
I don't believe so. Have you ever had an attorney?
Mm-mm.
No?
No, sir.
Okay, so I'm giving you the opportunity to get one
I just
before
would
you
like the
come
record
back.
to reflect that this is a case that occurred in 2021 in May, and I believe was accused in September of 2021. We can look at times it's been on the calendar. But today, May 24th, 2024, the issue of counsel is now coming up.
Okay.
Thank you.
After advising him, I take it that the state does not have any objection to me allowing him to seek counsel.
Absolutely not. It just delay or the fact that these cases are not being resolved should not be attributed to the state at this point.
Okay, if nothing further this morning, I think that completes our calendars. You all have a very safe holiday weekend. Ms. Parker, thank you so much. We appreciate you helping us out today. Thank
You're
you.
very welcome. Have a good day.
Do the same. Thank you.
Make sure you
Get a lawyer.
get it too. Like, make sure they got the right address.
Say it again.
Want to know